Once again, we are back in Okaloosa, Florida with pro se defendant Mr. McDonald. Without a lawyer, without a computer, and without proper access to legal tools, Mr. McDonald fights to get his motions heard. But clerical errors and tech gaps send the case into chaos, forcing the judge to step in and keep it from unraveling.
Good morning, Mr. McDonald.
Good morning, sir. How you doing?
I'm doing great. How are you?
All right.
All right.
I could be better.
All right, Mr. McDonald, obviously, just to bring it up because we have to talk about it every time we're here for a critical event in your case. You're currently representing yourself, is that correct?
Yes, sir, I am.
All right. Raise your right hand, please. Do you testimony about to give the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Do you still want to proceed as your own attorney?
Yes, sir, I do.
Okay. Are you still aware of the advantages of having an attorney?
Yes, sir.
Are you still aware of the disadvantages of not having an attorney?
Absolutely.
I mean, we've gone over this before. I want to make sure I say this too, because of some other recent case law. I'm not trying to encourage you to have a lawyer or anything like that, but I still have to ask you those questions and make sure that you want to proceed on your own.
Yes, sir.
Is that accurate that you want to proceed on your own still?
Yes, sir.
Okay. Again, if you ever decide that you'd like a lawyer, you can file the appropriate application, and I can, if you're found indigent, I can certainly appoint a lawyer for you.
Yes, sir. I understand that.
So how would you like to handle your case? I know last time we were here, we talked about, you had asked several times about a pretrial adversarial hearing, and we talked about that, made sure you understood what that was, that the probable cause determination had been made at your first appearance, and information was filed in a timely fashion. So I'm not sure that one really applied. And you were kind of, at that point, you were like, well, there's something else I'm talking about, but I can't remember the name of it off the top of my head.
Yeah, just to revisit that for one moment without wasting the court's time, is that I had never went to first appearance initially. And so that's why I filed that for that non-adversarial hearing.
You never went to first appearance.
I never went to first appearance for that. And that's why I filed that. And I was under that impression. And therefore, when you said that I was not allowed to have that, then.
Let's see.
There is no recording of that, of a first appearance for that.
Just take a quick look at
Recommitment of.
Is that on both cases you're saying that's the case?
Well,
both cases you're saying you didn't have first appearance?
No, sir, I did not. Not 1950 case.
Not the 1950.
Not the 1950.
So you're saying
For the 2917.
2917
Yes, sir.
case, you never saw a judge for first appearance?
No, I did not. There is no recording for that.
Well, here's the situation. I'm looking at the first appearance paperwork, Mr.
Yes.
McDonald. On December 23rd, 2024, you refused to come to first appearance?
No, I did not refuse it.
Let me finish. And then again on 2024, 12/24 of 24, it says that you refused. So.
Is my signature on it?
Well, no, because you refused.
I don't remember refusing that.
Okay, so a probable cause, it's called a non-adversarial probable cause determination,
Right.
which means the court makes it based on what the report says.
The A form?
Yeah, some people call it an A form, some call it a PCA, a probable cause affidavit. I practice in pretty heavily in at least 5 different circuits, and I think it's called something different. Just like almost everything's called something different in every circuit. So yeah, it's an A form, it's a PCA, it's an arrest report. That's why they call it non-adversarial. It's not an adversarial hearing.
Yes.
And then as far as the other thing you were talking about is, if you hadn't been charged, but you have been.
Well, I had been, yes.
So I just wanted to make sure we kind of had discussed that. I went back and watched it again yesterday just to remember, because obviously you're appearing pro se. And I want to make sure I'm reviewing those things.
I understand that you said.
So how would you like to proceed with your case? Because I know we talked about your alibi witnesses and you want them subpoenaed.
Yes.
But I really need to know what exactly you're wanting as far as what you want set for a hearing. Because Mr. McDonald, you filed quite a few things with the clerk's office. I told you this last time. When they come in, I get an email, I read them.
Yes.
But I have to make sure I understand what you want set and why, because I'm not trying to be critical, Mr. McDonald, but obviously,
I understand that.
you haven't done this before, really, right?
I have done it in a civil realm.
In a civil realm, but in a
Yes.
criminal case, because you don't have the access to just get on and e-file something. And,
I don't have that access. I don't have access to a computer. I don't have a Black's Law dictionary. So sometimes, it struggles, and then I have to read it to understand it. But it's not that I don't have a basic knowledge of it. The thing is that I have filed, the last time we were here, I spoke about that it was not warranted about the notice of discovery. I've not received no discoveries at all.
Has the state filed discovery? I think we talked about it last time because we specifically
Yes,
talked
and it
about
wasn't warranted at the
Mr.
time.
McDonald, I'm not interrupting you. Can you? Everything has to be said on the record. I want to make sure the recording's good so a transcript can be made. This is to protect your rights. But let me just finish. I know we talked about it last time because, again, I reviewed the video recording of it yesterday in preparation for today.
Yes, sir.
And we talked about that the state would mail you, because we even talked about the fact that it comes in and they scan it and they put it on some sort of tablet for you, which you weren't happy with. And I'll tell you the same thing I told you back 2 months ago. I don't have any control on jail policy as to how that stuff works. But has discovery been mailed to Mr. McDonald?
I believe it does. I was double checking now with my assistant. The other thing, Your Honor, most definitely we can deliver even the paper discovery, the reports and all of that. Via the investigator, like we can drop it off.
Has it not been done?
It might have been mailed out. I'm checking, Your Honor, to verify.
Does he go before RCC? Here, I found him. 26.
We did send it, Your Honor, probably to his previous counsel. Obviously, we haven't sent the brand new cases that he was arrested for recently. I haven't even reviewed the very last one yet.
Okay. When did you ask for discovery on case?
On January 31st.
Okay.
Is when I sent for notice of discovery. I do believe. Let me check my documentation. Notice of alibi. Oh, no. Yeah, January 30th, 2025, notice of discovery sent to clerk, judge, and state attorney.
Okay. I see. What I have, and you said February 3rd, but I get it. My date is based on when it got
When it got
to the clerk's office, which was February 6th. It's called Defendant's Discovery Exhibit. And
I didn't file it as an exhibit.
I just want to make sure that we're all on the same page.
Yes.
These are the people you're saying are defense witnesses, right?
Right.
Did you file a notice to participate in discovery?
Notice of discovery is what I filed, Your Honor.
When was that?
On January 30th. It's in my documentation.
Oh, okay. I'm just trying to find it, sir. You think you mailed it on January 30th?
I did mail it.
I'm just making sure, when we're talking about which date so I can find
Yes,
it.
I know it on the 30th, so the clerk of court should have received it on the 3rd at the latest, maybe the 4th.
I just don't see anything on those dates. That's why I'm trying to make sure. Because the only thing I see is on February 6th is the motion. It's called Defendant's Discovery Exhibit. And it's you saying these are the witnesses that I have.
No, that was my obligation to the notice of discovery. I don't know why it's not registering that, because I filed a notice of discovery.
I'm reading what you titled it.
Yes, sir.
And I'm reading what you put on there, which is you listed witnesses. What you didn't say, let me just finish reading through it. Is that you're electing to participate in discovery. Now, one could certainly imply or assume that's what you intended, but the state doesn't have to give you discovery until you ask for it, and your document doesn't exactly do that. And I'm not trying to be hypercritical here, but just making sure, because what happens is if you never ask for discovery, then you're not required to provide any of the discovery you want to give them. It's an election by the defendant to participate in discovery.
I have the memorandum at the jail. I didn't bring it with me today, but I have the memorandum from the clerk's office stating that I filed a notice of discovery.
I'm trying to find it. I see a discovery exhibit was sent.
Yeah, we did send all discovery to his
The
attorney.
defender's office.
In two cases, 24 CF 1950 and 24 CF 2917. As of in 24 CF 1950, we sent up to the 4th amended discovery, and at the end of January 2025, in 24 2917, we sent it on January 25th to Defense Counsel. We have not yet reviewed 25 CF 713. We haven't even filed any information on that.
A 713?
Yes, it's a brand new case, 25 CF 713.
Is that on this docket?
It may not be on this docket, no, Your Honor, because I'm just saying that if he's expecting that discovery for the newest case, I don't have it ready.
No, I didn't file for that. I had already filed a notice of discovery on the 30th of January. I don't know why I didn't do that. If I knew that was going to be an issue, I would have brought the memorandum.
Mr. McDonald, it's not about an issue or not. I'm just trying to make sure things are being done.
Yes.
But you have to file something that triggers them to have to act. And all I've seen so far, and I'm trying to look at the 1950 case now, is anything.
Your Honor.
Hold on. All right. So what I'm finding now in the 1950 case is a notice of discovery that you did.
Yes.
That was received on February 11th. And although it has both case numbers on it,
Right.
It's only in the 1950 case, because
Okay.
that's probably the top one. Normally it's better, and I know you've got limited resources as far as the paper
Yes.
to write it on. But if I could, Anna, is that something where they would normally just put it in both if it's got both case numbers on it?
I consolidated it, and then I sent.
Well, no, there's no consolidating a criminal case like this
Because
unless they're about the same facts.
the
But
ability-
I understand what you're saying.
Yes.
I'm just trying to make sure that when you do that, they end up in both court cases, because that may
Yes.
be the issue is it only went to one file and not both.
Yes.
And Ms. McDonald, I'm doing this not to be difficult. I'm doing this to try to make sure things are going correctly.
Fairly.
Because normally what a defense lawyer would do is e-file it under both case numbers, so it makes sure to get there. So, all right. So, what do you think you're missing as far as discovery at this point?
All of it.
You don't have anything,
I
even the
even
stuff
wrote-
that was provided to the public defender's office when they were representing you.
I asked him. I sent him a correspondence. When we left here in February, and requested it from his office too. Nothing.
Judge, I've asked my secretary to send over discovery to him.
All right.
Check with
This
him.
is what I'm going to order.
Yes, sir.
State is going to send over a copy of all previous discovery that's been done and obviously any amended discovery exhibits in the mail to Mr. McDonald no later than tomorrow. It just needs to be done because Mr. McDonald doesn't have the ability to constantly come back in front of the court and doesn't have the same resources that a lawyer would. So I want to make sure that's done. And I'm not trying to be difficult about it, but y'all got to get that stuff over to him. I understand what probably the concern is with the 2917 case is that the notice of discovery was never filed in that file, even though he wrote that case number on the one that he filed. So that's probably where the problem was.
Yes.
You have to understand, Mr. McDonald, when they churn through literally thousands of cases, if the case number isn't on there properly, it doesn't get e-filed the way their system usually takes it, it might not end up in there. So that you've got to make sure it gets into each file. So you're actually better off doing separate ones for each case. Because cases don't get consolidated.
I think I went and sent the clerk and requested that to clarify that I wanted to clarify that and that they were separate notices. But I understand that I see that you see it, so you know it was sent.
I see it now.
I did it in a proper manner, so it wasn't technically done in separate forms. So I do understand.
So make sure all discovery gets done in the first two cases for sure. Did you file something on the new case? We don't have court. You've got court on that next.
I filed an
next
objection to the probable cause for lack of probable cause, and I filed a writ of habeas corpus on it because of that. I didn't have prompt first appearance, and I filed a motion to dismiss it because it's under circumstantial evidence. There's no link for me.
I'm not sure. You're speaking way too fast, Mr.
Yeah.
McDonald.
Well, I just familiarize myself with it so much. I mean, that's all I have time to do is just do legal work and study it.
Well, I understand. I'm talking about the new case, the 25 CF 713.
Yes, and that's what I'm talking about.
You had a first appearance on that.
No, I did
I
not.
see your signature right here.
No, Your Honor, that is not correct. I was already incarcerated. So I asked the pretrial lady there that I had already previously, when I had arrested on that, to call Brad Stewart's office. I did. I had my family members call Brad Stewart's office so I could get represented by an attorney for that first appearance.
I understand, but you had a first appearance on April 8th.
No, I did
You
not.
signed the paperwork.
I got arrested on the 4th of April, and on the 5th of April, I was to be in first appearance. And when I went to the video prompt, the pretrial lady called me. If I was the first one to be called, I said, look, I'm trying to get an attorney for this first appearance hearing.
Your Honor, may I ask to set this matter for a motion hearing so that we don't hold the court's time? And
Yeah, I understand. Mr. McDonald, well, I think what we need to do is set a hearing date,
Okay.
but I need to know what motions you want to have heard
On the hearing date for what case, Your Honor?
or whatever you'd like to have heard.
I
Mr.
would-
McDonald, you filed a lot of things in all of these cases.
Okay. And
A lot of them aren't exactly correct. And I'm not trying to be critical, but
Right.
but I'm trying to get you to explain to me which motions you've made and that you'd like to have heard.
Okay. For the record, Your Honor, for the 1950 case, I filed a motion to compel after the request for the notice of discovery and a motion in limine. I'd like to have a hearing date set for that.
Did you file a motion in limine?
Yes, I did.
What date
In the
was that?
1950 case.
In the 1950 case. When did you file that? I've got one that's listed as February 24th.
That may be it.
You know, I would ask that we determine with precision the motions that are going to be heard, because obviously I need to respond, I need to prepare for them, but it's impossible based on the number of frivolous filings that this defendant has filed in the cases. And additionally, I have to say that I have a great difficulty trying to interpret his handwriting. I understand he's got difficulties, but I don't know if he can have access to some kind of laptops so he can type instead of handwriting that, because it's really, really hard.
There is one available, but they won't allow me to have one.
Well, I think I said this last time. Sometimes the handwritten motions look great. Sometimes not so much. And it looks like so much. I think we talked about this last time too, writing all capitals or block letters. That's the same way I write, but some of them are a little difficult to comprehend. So I understand the state's position on that. So, normally, we don't do our motions in limine until the case is set for trial. So let's see what other motions do you want to have heard?
In the 2917 case, I filed a motion to dismiss that based on the alibi witnesses and that I was physically impossible to be there on that date.
So for instance, Your Honor, this motion to dismiss could not be heard because, for example, I have the right to depose this potential alibi witness that he has.
Okay.
And I don't even know who that person is.
Trying to find, when was the motion to dismiss filed?
I didn't bring the memorandum with me on that, Your Honor, not today. Sorry.
May I propose something, Your Honor? Can we come back on Monday? And so Mr. McDonald has the time to maybe write the court and myself a list of what he really wants to set for a hearing.
I can do that.
So we may have more time to discuss that on Monday during docket day.
I'll have that in the mail this evening for her.
All right, we're going to bring you back on Monday.
Okay.
Give us a list of what you want to have heard.
Okay.
And I would like, I mean, Ms. Leone, if his discovery could potentially be delivered to the jail before then, that would be great.
I will try, Your Honor. I'll have our investigator. He was not in the office today, but hopefully tomorrow he is.
Right. See if they can drop it off at least. That way he'll have it before Monday.
Mhm.
And then we'll use Monday as a way to kind of figure out what motions we're going to have set. But you got to be prepared to tell us what exactly you're looking for, because again, Mr. McDonald, I've read all these and sometimes they're not easy to understand what you're asking for, or you're asking for things under the wrong rule, or you're not complying with the rule. So I just want to make sure that we're covering everything, but they have to be done correctly.
Okay.
Just because you're pro se doesn't mean I can, kind of give you a break on some of these things.
And I don't have all the ability that's afforded to others, if I was on the street.
Well, I understand that,
But I will have Mrs. Leon's in the middle of the night. She may not get it till Saturday.
well, I would expect she's probably not going to get it at all if it's not mailed out, and
I'm gonna have it in mail tonight.
we'll see if she gets it or not.
Okay.
All right.
Thank you,
Mr.
Your Honor.
McDonald. We'll see you back on Monday.